This is Duke University.
Is this live? Welcome to the 10th Annual Meredith and Kip Frey Lecture in Intellectual Property. I'm Artie Rye, and I teach patent law, law and biotechnology, and administrative law here at the law school. This lecture was established by our 1985 graduate, Kip Frey, and his wife, Meredith. Kip has had a terrific career in law and entrepreneurship. Currently, he is the CEO of Evo App, a software firm that assists businesses in the analysis of social media, such as Facebook and Twitter. Before that, he was CEO of Zenth Sound Innovations, a music software company. And I'm sure that at least some of you know him as your entrepreneurship professor and as the director of our law and entrepreneurship program. Kip's dedication to the law school and to creativity and collaboration in the field of intellectual property and innovation is underscored by his support of this lecture series. Thank you, Kip and Meredith. Each year, the Frey Lecture brings a distinguished scholar or practitioner to the law school to discuss issues related to intellectual property and innovation. This year, we're particularly honored to have with us David Kappos, Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office. Director Kappos was nominated to his position by President Barack Obama in 2009. He had previously served as Vice President and Assistant General Counsel for Intellectual Property at IBM, where he directed IBM's worldwide intellectual property operations. Director Kappos has already developed numerous policies and procedures to speed up the patent review process and improve patent quality. He is also a key architect of the landmark Leahy-Smith America Invents Act, which President Obama signed into law just this past September. This historic law, which represents the most important legislative patent reform since at least 1952, and maybe since 1836, will give the PTO even greater power to ensure patent quality and improve patent processing. I had the privilege of serving as a policy advisor to Director Kappos in 2009 and 2010. So before I turn the floor over to him, I do want to note one personal anecdote that I'd like to share with you from those days. I think it's fair to say that Director Kappos's work habits are the stuff of legend. Even before I came on board at the PTO, I'd heard what I thought at the time were tall tales. Once I joined, I found out that the tales were entirely true. Director Kappos is prone to sending out detailed emails about complex patent law intricacies at times like 1 in the morning or 5:30 in the morning. In fact, a favorite pastime among the PTO senior staff was figuring out exactly when Director Kappos slept. Since this was a bunch of nerds at the PTO, everyone had data on the timestamps of our emails. I think we determined it was between 2 and 5 in the morning, maybe. Well, true to form, Director Kappos arrived here at 8 this morning, having taken a flight from New York at the crack of dawn. He has already hosted a meeting of the White House Business Council here at the law school, done some media interviews, and had several meetings with law professors and attorneys. So this is just, just another day for him, and actually probably an unusually easy day at that. I give you Director Kappos.
Thanks, Artie. Well, good afternoon. Artie, thank you very much for that wonderful introduction. It is truly a privilege to come and be able to spend time here at the Duke Law School and to deliver this annual lecture this year. And it's always a privilege to get to collaborate with my partner in transforming the USPTO from the very beginning, Artie Rye. And I think it's fair to say that that I probably wouldn't be doing the job I'm doing now had it not been for both Artie's encouragement and partnership for so many years and directly at the agency. And so thanks for inviting me and for the years of collaboration which continue to this day. Also like to thank Dean Levy and Kim Frey for not only hosting the United States Patent and Trademark Office here in Raleigh-Durham today, this area being a true, I think it's fair to say, center of American innovation, but also for giving us the opportunity to speak to so many academics and students and current leaders and future leaders in the field, exactly the people that we need to be interacting with at our agency. Now, as Artie mentioned briefly, today what I'd like to primarily address is what President Obama's signing of the America Invents Act into law just about 4 weeks ago means for American innovation and American jobs and American leadership. And in getting to that, I'm really happy that so many of you have taken time from your busy schedules to participate in today's discussion. And the reason I say that is because even though many of us in this room are tech denizens, nerds, as Professor Rye has pointed out, and we're in, after all, Research Triangle Park, one of the tech meccas of our country, having spent nearly now all of my career in intellectual property, I will tell you that that patents haven't always been the sexiest of topics in any kind of company. But even if that brand new patent reform legislation isn't enough to make patents a dinner time conversation in general, take a moment and look around you and think about the impact that intellectual property in general and patents in particular have on all of our lives, from the microprocessors in the camera that the photographer is using up here to the components in the microphones that hopefully some of you will use in a little while to ask very polite and academic questions, to the official seal of the Duke Blue Devils, all patented technologies, in the case of course, the seal and the logo, trademark protected technologies that sought protection at the United States Patent and Trademark Office. And so no longer are we living in an era where intellectual property is a topic reserved for the technical and the specialized and the scientific. It now is something that touches all areas of society, all levels of interest, and all parts of our daily lives, right? And so we're bearing witness to this awe-inspiring progress of technology at a pace never before seen by any previous generation. And in that field, in that time that we live, protecting technologies with clear and consistent and dependable patent rights it's become absolutely fundamental to disseminating scientific advances and affording society, right, the opportunity to build from one new discovery to another. And this cardinal prominence that the patent right has taken on, indeed, as many of you in this room know, if you've taken con law, and maybe even if you haven't, was codified by our founding fathers right there in the Constitution. While drafting that document, they deemed it essential that society would promote the progress of science and the useful arts by granting inventors rights for limited periods of time. And we now know without these incentives offered by patent protection, in fact, there'd be little motivation in many cases for anyone to share their great new idea, whether it's the idea for the laser, the idea for the microprocessor, or any of the other millions of ideas that have seen their way through the U.S. patent system over time. There'd be little incentive for them to share, and in fact, plenty of incentives for them not to share. So the patent system has made a fundamental difference in our country from the very beginning. You take an idea like the laser alone, right? It spawned whole industries, right? Through multiple uses, multiple follow-on breakthroughs, right? As if gazing into the far depths of our galaxy, enabled by lasers, or correcting visual impairments, enabled also by lasers, weren't enough, right? Follow-on advancement technologies spawned by the basic innovation of the laser are continuing to this day to create whole new job sectors, not just jobs, but entire sectors of growth for our economy. So it's with that experimental drive, curiosity, and foresight that our founding fathers left this legacy that we now know is so profound that our faith in the transformative power of American inventiveness has become almost a matter of genetic predisposition for us, and this belief that innovation will grow the next generation of industries and promote waves of new jobs, that innovation, even in the face of occasional failure, will provide us with greater understanding of the world around us, and indeed that innovation will underwrite the next great chapter of American growth. We just believe that. And that's exactly why the America Invents Act is an historic piece of legislation for our country. Because in the centuries since that first patent examiner, Thomas Jefferson, reviewed and granted U.S. patents, right, our nation has observed absolutely sweeping revolutions in the pace of innovation, but no concomitant, comprehensive legislative adjustment in patent policy. So as Professor Rye mentioned, this patent reform legislation is perhaps the biggest thing to happen in the patent world since 1956, or was it the 52 Act. I have frequently said that it's the biggest thing to happen since when Senator John Ruggles created the examination system in 1836. And there are some who are saying it's the biggest thing to happen since Thomas Jefferson put together the first examination process. Whichever one of those is right, it is clearly a big, big change, and I think a very positive one for our country. And so by building out the world's first and only 21st century patent system, right, equipped to manage the demands of a globalized economy, this new law enables a better resourced USPTO to grant IP rights with greater speed, with greater clarity, and greater quality, right? And it also, incidentally, significantly advances the President's overall strategy of deploying American innovation to build businesses and build jobs for our country. We believe that by cutting costs for independent inventors, entrepreneurs, and issuing patents that obviate expensive court challenges, and by providing tools that enable us to reach patent decisions now 3 times faster than in the past, the new law absolutely topples many existing structural impediments to business and technological growth for our country. With this greater efficiency built into the new American IP system, investors will have greater confidence in the American patent. And as you all know, it's investors, it's that for investors, the patent right is a strong indicator of the potential of a new enterprise, a new company. And for inventors, the other guys involved in this process, patents are essential to attracting capital to develop their products. So by allowing universities like Duke and all the other great universities here in North Carolina, and early stage startups and independent inventors and even more established larger companies to effectively acquire the capital that's required, our newly reformed patent system, I truly believe, is able to turn inventions, right, to developing better products and services faster and enabling Americans to hire employees sooner and grow their businesses stronger and sell their products more widely. So this new historic patent law is actually, in that sense, a down payment a down payment on President Obama's agenda outlined in the American Jobs Act. By shrinking the gap between ideation and the bottom line, companies are now able to leverage the resources required to move molecules into the marketplace, spurring the sort of business and economic growth necessary to out-innovate our economic competitors globally. Ultimately, this ensures new jobs and new industries take root in this country, in our country, and not elsewhere. Now, one of the areas where we've seen a strong linkage between competitiveness and economic growth and a direct correlation to employment opportunity is in what we call IP-intensive industries. Now, these are industries where we see a large representation here in North Carolina, in RTP, where great ideas, commonly born in labs, garages or dorm rooms or whatever, have blossomed into Fortune 500 companies. The reason? Because they've had the strength of the US patent behind them to build out the far-reaching products and services that benefit communities and economies generally. But it turns out that sound IP policy, the kind that's embodied in the America Invents Act, doesn't just embolden American manufacturing sector or inspire new innovative possibilities, as I've mentioned, as if that's not enough for the only bipartisan business legislation to pass this Congress. I'll not forget to mention, it also helps the American innovator to compete by offering clear, timely, and enforceable IP rights, right? And so we all know that we live in a world where the corrupt can so readily steal and mimic and distribute products as if they were their own, right? That clarity and consistency in intellectual property rights is where the action is, because clarity and consistency help American businesses to protect their IP from theft and give American businesses a fighting chance to compete on a level playing field internationally. Now, none of us needs a lecture on the sinister competitive impacts of counterfeiting and piracy, so I'm not going to spend time on that today. But below the surface, there is an equally insidious impact on national competitiveness, and I do want to spend just a moment on that, because these copyists enjoy free, in quotes, free access to others' property. Their operating costs are concomitantly reduced and relative to legitimate US businesses that have to pay for access to others' property or develop their own property and pay the cost for research and development. So it shouldn't be surprising in that regard that these rogue competitors actually have a significant marketplace advantage over US competitors, right? Cheaters cheat for a reason, and that's why. And the cost exacted to cope with that unfair cheater's advantage don't just shrink revenues, right? They inhibit more product development for legitimate companies. They stunt business growth for US businesses. They reduce potential hiring, and they risk irreparable damage to brands, right? And in the sum, they ultimately stymie broader economic growth for our country. Now, what the AIA does to ensure that entrepreneurs and innovators and businesses of all sizes and all scopes have the best tools available to protect themselves and to participate in markets in this hyper-competitive and often ruthless environment is through a set of provisions that promote IP policy in a very sound way, governed by three basic pillars or principles: speed, quality, and clarity. That's what you can boil this law down to. Speed, of course, in the patent process, in the patent application process, is paramount to inventors to get their businesses off the ground, right? But speed alone is not enough. The USPTO and this new law places a primary premium actually on ensuring that only high-quality patents pass review. And speed in the patent application process combined with high quality is what produces a system that will be sought after worldwide. Now, a commitment to the pillar of quality, to go a little further with that, in our office has led to tighter standards, right? Standards that are helping cutting-edge products reach the marketplace securely while allowing manufacturers to do business without the threat caused by improvident patent grants. And finally, I mentioned clarity. Clarity in what exactly is covered by a patent and for whom, right? Who is the owner? Who is the assignee? Clarity moves the patent system away from constant challenges caught in the dockets of district courts all over the country to mutual respect and accountability for innovators and manufacturers and the public. And that's really what we want from our patent system. So let's talk just a little bit about how some of the specific provisions of this new law meet the three standards that I've mentioned and give the U.S. the world's first and only 21st century patent system. First of all, importantly, for the first time, the USPTO will have the ability under this new law to set its fees and recover the actual costs of the services that we perform. And for the first time, the law helps the USPTO access all of the fees that it collects. And before the ink of the president's signature was even dry on that document, we began testing those points by aggressively beginning to implement this mandate by hiring new examiners. So any students in the room who might be interested in a job after graduation, USPTO is hiring new examiners and lots of them, instituting new processes and modernizing our IT systems, to name a few of the things we've done. Now, while we're in some tough economic times, we all know, and our funding model is still not perfect after this legislation, we do appreciate the strong and sustained support of members of Congress and our stakeholder community, including great universities like this one, to ensure that the USPTO retains the funding that it needs to implement this legislation and the accompanying core programs that we're putting in place. Now, to move to the substance, to alleviate an average wait time of almost 3 years for a patent application, we've already begun offering inventors an opportunity to have their patents reviewed in 1/3 that time, right? With the new fast track one option that I think I can fairly say Professor Rye was my key partner in devising from the very beginning. We can now provide 12-month turnaround to patent applicants, only office in the world that does that. The Track 1 prioritized examination provision enables the USPTO to move with urgency that matches the urgency present in the marketplace and moves American ingenuity into the private sector much more quickly. Now, our users have taken to this program pretty quickly. They've already filed in financial year 2011, which ended just about a week after the law was signed by the president. We received 853 fast track or track one applications, with 171 additional applications received in the first couple of weeks of financial year 2012. So I think it's fair to say there is a market demand for a fast track process, and the U.S. intellectual property user community has taken it up pretty quickly. Now, the legislation also enables us to bring online additional resources needed to help further combat the backlog of patent applications that we're dealing with, which you all know represent an untold number of jobs and innovations that are sitting in an idling pipeline, not getting into the marketplace. Under the Obama administration, the backlog has been reduced so far from about 750,000 applications to less than 670,000 applications, despite a 4% increase in filings. However, we have a long way to go. So we're still just getting started, although I think it's fair to say that we made some progress so far. But additional resources provided by the law, the substantive new changes to the law, are allowing us to push that number down even further and even faster and continue to unclog those backlogs and produce American jobs. The law also establishes a new in-house review process for challenging granted patents, the other side of the patent pipeline, a process that's going to be much faster and much cheaper than litigation in an Article III district court. We believe that by resolving disputes about patent rights earlier, right, and more efficiently and at lower cost, all of which are the basic tenets of the new post-grant review procedure, will add greater clarity to and greater confidence in the American patent system. Now, that confidence in turn will invite more companies to do business in the U.S., inspiring individuals to work toward the next generation of inventions, whether they're medical devices or nanotech breakthroughs, all of which you make in this part of the country that will sustain Americans' visionary leadership for generations to come. The AIA also promotes a system of clear and more enforceable patent rights by adopting the so-called first-to-file standard for patent priority, right? By transitioning to this simpler, more objective, more transparent system for determining patent priority, the new act helps ensure that independent inventors and small entities have access to their rightful claims to patents and are able to navigate a patent system on a much more equitable, much less complicated footing vis-a-vis larger enterprises. And let me be clear about this. Independent inventors and small business entities play an absolutely critical role in driving innovation for the U.S., creating fully 2 out of every 3 new jobs in our country. And that's why this new system was specifically designed to better protect the new entrants by offering to small businesses a more reliable way of filing that can better withstand the challenges, right, from competitors and can help them to reduce their costs. Now, with the new law in place, the U.S. will enjoy objective standards for assessing patentability, standards easily applied by our examiners at the USPTO and by applicants alike. And of course, as you all know, that is the foundation to quality. When you think about quality, foundation to quality is built on clear, objective, and simple standards. And that's what this new law encompasses. The new law also permits third-party submissions of prior art for the first time now with commentary, and we're implementing that system so that it can be effectively used via the 21st century communication tool of choice, the internet. This piece of technology, not the internet, but third-party submissions of prior art, as I frequently put it, is the USPTO meets the 21st century. It's applying the concepts that you use every day that you benefit from, tools like Wikipedia, among others, that allow us to harness, right, the wisdom of the crowd and to, in a way, open source the process of searching for prior art to get the very best art, documents that exist in the literature, the very best prior art in front of our examiners, widen the scope of their review, and offer patent applicants heightened confidence in the validity of their patents once issued. Now, stepping back a little bit, the sheer tonnage of all of these provisions in this new law will certainly be a challenge for our agency to implement. But we stand at the forefront of this new era of American innovation. I will submit to you today that the United States Patent and Trademark Office is up to the challenge. And I don't say that in an insular or in any way arrogant fashion, but I say that because in its totality, the America Invents Act fosters a nimble and strong IP infrastructure for our country that allows businesses to grow and technologies to flourish, right, by leveraging innovative efforts with the fulcrum of the U.S. patent, the currency of 21st century innovation. And because of that basic tenet of this legislation, it is going to be implemented by the entire U.S. innovation community together, not the USPTO in isolation, but all of us working together to successfully translate a skeletal set of laws into an effective implementation, in part on the part of the agency and in part on the part of our huge and capable stakeholder community. So our new law, as I've said, is anchored in this desire to more effectively match the rate and pace of the patenting process with the rate and pace of invention and the rate and pace of commercialization. But in saying that, I realize that there's a difference between invention and innovation. The latter is the economically relevant version of the former, right? So with this distinction in mind, the America Invents Act creates not just the simplest patent system or the most precise patent system, but rather the most innovation-friendly patent system, the most inventor-friendly patent system, the most collaboration-friendly patent system, which should be very attractive to the academy as well as business interests that increasingly have to collaborate in order to turn ideas into marketplace offerings. The process of implementing this law will span the next 18 months plus, actually 2 years probably plus in the end. But as we develop the new system of rules to implement the many provisions in the law, input from the academy in particular, as well as industry, as well as the entire innovation community, as I've mentioned, is going to be vital to us. We've already convened working groups within the agency. We've already reached out to the academy and to U.S. business and the large stakeholder community. We've even reached out globally. We're already working on implementation of the new law. And again, we're doing it together as an entire IP community. And of course, North Carolina represents one of the central brain trusts of American innovation, so I'm especially excited to be here to encourage you to be part of the dialogue, part of the process, submit comments, ideas, complaints, whatever. It's very easy to do that via the dedicated America Invents microsite on the USPTO website. We've already got that open up for business, and it's got tremendous content on it that will be updated a lot, including with the many presentations and speeches we're giving all over the country to begin educating the U.S. community about this new law. We've even reserved a 1-800 telephone number. I think it's 1-800-AIA-HELP. And we're in the process of staffing it, so you'll soon be able to call in and speak with an actual USPTO professional. This is not being outsourced in any way. It's someone from our agency who will be able to answer questions for you or get answers to questions, or importantly, in many cases, tell you when we don't know the answer either, because there's so much about this law that remains to evolve over time. Now, we believe nonetheless that through judicious rulemaking and thoughtful guidelines and a policy-based approach, right, interpretations by the courts that are thoughtful, that are advanced quickly by USPTO action through our Corps of Examiners and then through our Board of Appeal and through our new trial board of new judges that we're just now putting on its feet, that we can animate the AIA with the balance and stability that are essential to business growth in our country. And when we're done with this, our new patent laws will streamline processes that optimize patent quality, minimize barriers to research and development and growth that have just plagued both small and large businesses in this economic for far, far, far too long. So we live in an age where technological change occurs in the blink of an eye. We all know that. Our new patent office, our new patent laws have to enable our office to be capable of adapting to change to keep up with that rate of innovation. And the law does that, the AIA does that. Not only boost confidence in the US patent system, but also, I believe, will boost inventor willingness to take the risks involved in turning ideas into reality, designing them and building them and mapping uncharted industries with ideas just like Americans have since the very beginning, well over 200 years ago. You know, we're a nation of big ideas. We've always been a nation of big ideas, larger than life ideas, and I really believe we still are. We're a nation that wakes up in the morning saying, I don't necessarily have a lot of money, but I got a great idea, and it's a great idea that can help other people, and I'm going to build it. And I might not know exactly how to get this thing off the ground, but I'm going to try, and I believe I might just succeed because this is America. We do big things in this country. And today, more than 2 centuries after Thomas Jefferson examined that first patent application, turning great American ideas into great American businesses, I believe has gotten the facelift of the century. And I'm just thrilled to be able to be the steward of the USPTO and work with so many talented people right now and with all of you in the USIP community to implement this great new law and make it a success for our country. So thank you very much. Artie, I think we've got plenty of time for discussion, right?
We do, yes. Thank you. So I will call on folks and generally moderate. We have about 20 or 25 minutes, what I'd like to do is get the largest number of people involved as possible. So why don't we go ahead and get started raising your hands. And yes, sir.
David Lane from Elon University School of Law. Mr. Kappos, this is a fascinating talk. I'm curious to get your comments on the transparency and disclosure trade-off with the diminishment of best mode versus the first to file, which potentially may have the impact of having more applications earlier in the process.
Yeah, so that's a great question. So transparency to me is the sine qua non of the patent system. By that I mean the basic patent bargain is based on disclosure. You know, the whole idea is that great thinkers disclose their inventions, get a 20- year temporary monopoly in exchange for dedicating their inventions to the corpus of human history for all time. And it's actually a pretty good bargain. It's a bargain that has withstood the test of time. Limited monopoly, incenting transparency and disclosure in exchange for mankind's platform going higher and higher and higher in perpetuity, right? So it's a great bargain if it works. I have not been pleased at all to see what I believe over the period of my career has been a gradual diminishment in the teaching quality of the patent corpus, right? My observation has been that patents, this isn't uniform, but in some fields, in some areas, seem to teach less and less and less over time as compared with, if you will, in the old days. Now, however, the fault for that, I do not believe rests on the best mode requirement. The best mode requirement was anachronistic to the US. We're the only country that had it, primarily a trap for the unwary. Examiners have never known how to examine it. They really couldn't examine it. They didn't have the tools to examine under the best mode. So I think focusing on sufficiency of disclosure, on clarity of disclosure, completeness of disclosure is really where the action is, not so much in the best mode area. Now, the new law, I think, will be very helpful in that regard in a number of ways. One of them is that it enables, through the post-grant opposition system, an all-in challenge to occur immediately after patent issues. So in cases where we don't hit, well, now I'll go into Gorpy patent geek talk for just a second, 112 first paragraph, 112 second paragraph, 112 sixth paragraph, where the basic tenets of clear disclosure, where we don't hit those right in our examination, now you've got a way to point that out to us and let us go back and take a second look at it. I think also provisions like the move to the first to file system, and I'll come back to that to answer the other part of your question in a minute, are going to be transformative to us as well. Because now for the first time in history, when an examiner picks up an application, she or he will immediately know what date to apply for prior art. And when they look at a prior art document, they'll know whether it is prior art or not. I came in already jokes about, work ethic and all that, but I don't know about that. But I will tell you, I actually did examine a patent application a while back. Came in on a weekend, sat down with an examiner, and went through the grinding process of examining a case. And I was shocked when we got to the part where we were actually starting to search the prior art and then try to apply it. I had never, sort of been on that side of the glass before. And when you sit on that side of the glass and you put yourself in the shoes of the examiner under the current system, you look at a reference, you can't tell whether it's prior art or not. It's absolutely silly, right? So we're now going to have a system where examiners can very objectively, very quickly look at documents and know whether they apply. That is all about clarity. It's about getting to done in a definitive way that everybody can understand. Now, the last thing I'll say, well, two more things, actually. One is, it turns out a lot of making the patent system work, a lot of the action in making the patent system work is actually in just making the USPTO work more effectively, right? We got about 7,000 going on 9,000, I hope, examiners at our agency. Great people, very, very smart people. But of course, they got a limited amount of time to work on each case, and they work according to the incentives they're given. And so for years and years and years, we hadn't really told them to examine for clarity, to examine under 112, to look, to read the specification and make sure that the claims were clearly enabled by the specification, that the claims did not claim vastly in excess of what was disclosed in the specification, that each term in the claim is found somewhere and defined somewhere in the specification, all these things that you would think are first nature. We frankly didn't give much, if any, instruction to do that to our examiners, and we didn't ask them to do that, and we didn't give them the time and the incentives to do that. Well, we changed all of that. Many of you who study here at Duke have probably looked at our 112 guidelines. I know Professor Rice pointed them out to me once or twice. We put out, for the first time in the history of the agency, guidelines for our examiners. It's just simple. You start telling people what to do, you measure them on it, you give them the incentives to use it, you give them the training, and they will start to do the new things that you want them to do. That point, the point of writing those very scholarly examination guidelines for Section 112, training our 7,000 plus examiners, giving them the time to do that work, and measuring the outcome, which we are doing, was all about the point of clarity, 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 making sure that specifications and claims map, and that we stop permitting overbroad patents to issue out of the USPTO. So that's next last comment. Just one more thing on first to file, because you hit a lot of good questions there. So there's a lot of speculation now in the blogosphere about first to file. Oh, is it going to cause people to flood the patent office with early filings? I don't think it is, and I don't think it should, and I don't think it needs to. And the reason I say that is because you're going to have the same disclosure requirements under the new system that you have now. So you don't want to file a speculative patent application today, because if you do, we're examining under 112 now. You're not going to get those claims because they're not adequately disclosed. If you've got a half-baked idea, right, and you disclose that in a patent application, you're not going to do yourself any good today, and it's not going to be any different under the new first inventor to file system. So I don't think the law needs to cause any change, and I think at the end of the day it won't cause much, if any, change in that regard. I think that clarity will be a premium because we're making it a premium, we're measuring according to it, and it will drive folks to do the right thing, which is to ensure they've got a clear invention before they file a patent application. So thanks for the question.
Sir, back there.
Yes, the question, my name is Joe Pearl. I'm a business owner and provisional patent owner. And the question was about the semantic web. So you were talking a little bit about making your examiners much more efficient and accurate as you go through this process. Really wondering where it's going sort of beyond just the Wikipedia and Google searches to almost sort of the IBM Watson type of advanced technology and approach so you can get it there, get it accurate, and get it done.
Yeah, so that's a great question. Thanks for being a provisional patent filer. Remember to roll that thing over before 12 months so you don't lose rights.
To put in for my utility patent.
Okay, good. Don't forget. And remember, you've still got, if you're still within the 12-month priority period, you can still make overseas filing. So don't forget about that. Now, to answer, can't help it. So to answer your question, semantic web is great technology that enables information technology infrastructure to enhance the effort of our examiners. Watson, thank you for speaking to that great innovation, is a very 21st century approach to adaptive searching that uses information technology to obviously stunning new effect. We are working to incorporate those kinds of concepts without pointing to individual vendors or individual products at USPTO in our next generation IT system, which is called Patents End-to-End. We actually have a professor on staff who Professor Rye brought in when she was at the USPTO. This other professor is not a patent geek. She is a tenured expert in information sciences from another great university, the one where I happen to go to school, University of California, Berkeley. Her name is Marty Hirsch. She's been my direct advisor. She reports directly to me and advises me on information technology issues, and she is all over this point and the need for our next generation system to have the very best of search capabilities so that, and we're beginning to fill it out. The first iteration of it is already being used in our central reexamination unit. There's a lot more to do. This is a multi-year project. You're talking big ticket IT. It's very difficult, but we're on that challenge. The vision, and keep up with us, if you want to see this stuff, we can demo it for you. It's very cool. The vision is for every examiner, when she or he brings up a new case, to have a search that's already done for them automatically, points them to the best prior art that the tools can find, that gives them the sample keywords to start doing their manual human-based search, that makes it very easy to triage the prior art and to apply the prior art. And that's the vision. Now, of course, it'll take time to implement that. And it's got a second component to it that's also very challenging you should know about, which is data. Access to data, right, is, even if you've got the world's greatest search engine, unless you've got the many, many millions of records behind it, you don't really have a solution. And unless you've got language translation capability, C to E, J to E, G as in German to E, et cetera, you don't really have a capable system. So we're trying to put all of those components together at the same time in order to be able to give our examiners really the world's very best search capability. It's in scope, part of the project. Yeah.
Yes, ma'am.
I'm Victoria Christian, Duke Translational Medicine Institute, and thank you for inviting us here. My question is, I like the characterization of the new law as pro-innovation, pro-inventor, pro-collaboration. Is there a lot of discussion about the potential to foster and effectively lead the way in such a way that global or multi-international collaboration will be not selected against? In medicine, we so often have a network of inventors that represent patent and trademark sort of perspectives that are in direct conflict with one another, and then the markets, of course, flow from there. I wonder if you have any thoughts on that.
So that's another great question, and you're in an area where patents mean business. You either have a patent position, or you're donating your inventions into the great global arbitrage, right? So yes, the AIA, for me, in part as the leader of the US IP system, if you will, was in major part about a new reassertion of US leadership in the global discussion about substantive patent law harmonization. It's really kind of sad that among commercial legal regimes, the antitrust laws have become, much more, I won't quite say harmonized, but much more endemic in standard ways, jurisdiction to jurisdiction. Copyright laws are very harmonized, trademark laws, and you can go on and on and on. The global laggard in harmonization is the patent laws, the laws that are supposed to incent global collaboration and global development are the ones that are the furthest behind. So we clearly have a problem with the patent system. The new laws in the US give us the perfect opportunity to get our trading partners to move along with us along the path to get all of our patent systems looking the same, so that the patent systems are an accelerant to global collaboration, which undoubtedly your company is doing, so that when one of your scientists is working with a scientist at Tsinghua, you don't have the problem of all these divergent laws and systems. We're working on that, right? This is one of the things that I came to the government to do. When we started seeing the AIA come together a year ago, right? It was actually a little more than a year ago. In fact, I think it might have been already when you were still at the agency. We began planning a reassertion of harmonization. We set up a meeting last March on the margins of the ACPC, the Asia Pacific the APEC, Asia Pacific Economic Cooperation Forum. It was this year was the US leadership of it. So the president had his meetings. We convened our meeting. We brought together the leaders of 20 plus Asia Pacific countries, the Japanese, the Chinese, the Koreans, all there. Had a great meeting. We came out with an agreed assertion that it's now time to harmonize the global patent system right on the back of the problem that you're raising. We took that immediately over to Europe. I've since had meetings in Munich and Paris and Geneva and London and Brussels, and I can't even remember all the other places, culminating in a kind of a mini summit that we held at Tegernsee on the 5th of July, 2011, Tegernsee, Germany, which is just outside Munich, moving this agenda forward. We since have put together with US leadership what's called the Tegernsee Group. They've created a matrix of harmonization. It's being filled out now. It'll ultimately be made, transparently available so that, folks in the academy can look at it. But it's all directed toward this problem of, on the back of US patent reform, right now that we have unilaterally fixed all of our harmonization issues, getting our trading partners to move their laws into the 21st century. So I happened to give a speech just yesterday, actually, to a group of German businessmen in Washington, D.C., who are transatlantic business dialogue or something like that. And I hammered the issue of harmonization, not because I was in front of a bunch of lawyers, but because I wasn't in front of a bunch of lawyers. These are business people who care about doing business between Germany and the US, one of the biggest trading relationships on the planet. And I really hit this hard and said, you folks need to go back and get with your government and get with your industry in your country and get things going like a 21st century grace period that we now have that makes it possible for academics to publish without losing their patent rights, to collaborate without losing their patent rights, to work with business without losing their patent rights. And I think that the time is now that harmonization is something we now can do on the back of US patent reform. We are, as I think I've made clear, we are all over it. Here in the US, and we're going to just drive that forward, especially with the Europeans, but also with the folks in Asia, and try and get to a system where you will not have to worry about the things that you're currently worrying about. Thanks for the great question.
I think we have time for one last question, and hopefully a short one.
And hopefully a short answer.
The startups that we've seen coming up in the last, 10, 20 years, I think the biggest and most effective ones we've seen are like things like Facebook or Google, and they're mostly software patent, software startups. And yet everything from the hyperlink to the shopping cart to things that are considered commonplace have been patented. The linked list program. How does the new law, or how does the plan and the platform of the Patent Office going after software patents, either as to clarify or to make more specific? And do you see that as an issue now?
Yeah, that is another legitimate issue. You know, there was a great piece of research done by another common colleague that Professor Rye, I think it's fair to say, single-handedly brought into the USPTO, who's been a brilliant partner of mine there, Professor Stuart Graham from Georgia Tech. And Professor Graham did a study with a number of other folks at UC Berkeley, I'm sorry, and Stu's also a UC Berkeley grad, so we seem to have something going on there. They did a nice study, though, that looked into the differences in patent usage between various industries. And indeed, one of the things they found is that in the software industry, right, unsurprisingly, for startups and high-growth companies, there's a considerably less dependence, less reliance, and even less interest in patent positions than in other industries, like some of the life sciences industries where it's all about getting a patent position. So there are differences among different industries, and they play out in the marketplace, and they play out in venture funding, and they just play out in everything we do. They also are linked to some of the problems, the challenges the USPTO and our patent system has had over the years with the subject of software patents, right? And it goes back to the question the gentleman behind you asked earlier with, unfortunately, through a number of circumstances, granting patents that have not withstood the test of time, patents that have proven to be overbroad, patents that in some cases have created an overhang on the marketplace rather than an accelerant to the marketplace. So we're gradually going through the process of sort of working through that. And you've seen the Supreme Court evolving the laws. The KSR decision is an important example over the last several years in ways that are sending a message to the whole U.S. innovation community, and especially the Patent Office, that they wanted stricter tests applied, and they wanted fewer of these marginal, hopefully none of these marginal patents, particularly in the software area. So I think the concern is a real one. The issue is a real one. There really are different industries that have different ways they use patents and different levels of reliance on them. I think that in the context of a unitary patent system like we have, we need to be mindful that we've got one set of patent laws, but I think we can be mindful and we can manage them within the agency in a way that's nuanced, that recognizes that different technology areas have different needs. And so we're actually doing that. We're working on the first set of guidelines that we've ever had for patent protection. And we're gonna wind up in like 30 seconds here. Yeah. We're working on the first set of guidelines we've ever had, and we're doing them in a way that distinguishes between software and biotech and other areas. So thank you very much for the question.
Thank you, everyone, for coming, and thanks to Journal Kappos.
Produced by Duke University. Online at duke.edu.